Welcome, everybody. Welcome to our training, Title IX's 54th anniversary, Sports-Oriented Gender Equity in Education, a primer. Um, Before we get started, we want to go over some logistics. In order to turn on live captions, please press the CC symbol below. This session will be recorded and it will be uploaded to the LAAC website within 1 week of the event. You will receive your MCLE certificate within 1 week. This training is eligible for 1 hour of general MCLE credit. Please feel free to use the chat function to ask your questions. We will try to get to them periodically throughout the webinar. And with that, I'll go ahead and pass it over to our presenters.
Thank you so much. It's wonderful to be here. We're so thrilled to be training on Title IX today on the 54th anniversary. As you know from the explanation, we're going to be covering the basics of Title IX in an effort to ensure gender equity in federally funded K-12 educational athletics contexts. And we're going to be focusing on intersectional equity, easy to apply tools, and we're going to give some updates on a very rapidly shifting enforcement landscape. So diving into who you're hearing from today. I am Kim Turner. I am project counsel with California Women's Law Center, and I've been fortunate to be advocating for Title IX and related matters for over a decade, particularly in under-resourced communities and communities of color in California and beyond. I am also a former attorney at Legal Aid at Work, the Fair Play for Girls in Sports project there, as well as Bay Area Legal Aid. And I played college sports myself, was fortunate to have that chance because of Title IX as a woman athlete, and I currently coach youth sports and am very active in the Bay Area and California youth sports community. Over to Elizabeth. Thanks.
Hi, everybody. Good afternoon. I'm Elizabeth Kristen. I use she, her pronouns, and I'm the legal director at the California Women's Law Center. Delighted to be presenting today on my favorite topic, Title IX and sports equity. This is an area that I've worked in for almost 2 decades now, along with the California Women's Law Center and previously at Legal Aid at Work. We litigated a case with the Women's Law Center against the Sweetwater District that has led to some really important precedent. But in addition to litigation, we have some amazing community education materials, and I will share a link in the chat. We're very excited to say that we just launched new materials about Title IX and how to enforce your rights for both lawyers who represent folks, community members, coaches, teachers. So I will put that in the chat, and hopefully you all can take a look at those materials, which we're very excited about. Back to you, Kim.
Thanks, Elizabeth. And Elizabeth and I have been fortunate to work together for a long time. Teamwork is critical in legal aid and advocacy work and equity work. So grateful to be here today, and grateful to LAAC for co-hosting this with us. Thanks for those who've joined us. We know some folks are joining live and some will be joining via the recording in the future. So welcome. And you, if you'd like, can introduce yourself in the chat. If you wish, you don't have to. But you can share your name, your title if you like, your organization, law firm, legal aid org, etc., and any items you wish to learn about. We do want to make sure this is interactive today. You know, a lot of folks have heard of Title IX or have a very general sense of it, but they don't have all the details, and they might have particular issue areas of interest that we want to either tackle today, or we could also set up a quick call with you in the future if you want to talk about something deep dive after the session. All right, so as people are putting in the chat their background, thank you so much. I will just let you know what we're going to be covering today. We have an hour booked for the Title IX portion of today, and then we have a few minutes after that when we're going to talk about California Women's Law Center and what the nonprofit organization does in the community and in California. So please do stay tuned for that portion afterward. But for the Title IX portion, we're going to be talking about the benefits of sports for girls, what is Title IX, Title IX in the K-12 and collegiate athletics context, with a focus on K-12, which is more our focus, but a lot of these same principles apply in college. We're going to be covering the current legal landscape in different respects, discussing and touching upon intersectionality in sports access at various times. And then we're also going to preview for you what the Fair Play Act is, AB 2404, which is a park and rec law based on Title IX in California. I do want to underscore that this presentation does not constitute legal advice, and please do consult an attorney for specific guidance in your situation. All right, so next, one of our favorite slides, one of our favorite sections about this work is what are the benefits of sports for girls and women? We obviously have made a lot of progress with girls and women playing sports at higher rates, but we still have a lot of communities, particularly communities of color and low-income communities, where kids, and especially girls, do not have as many sport opportunities as they really want to have and could enjoy. So I just want to also emphasize that California Women's Law Center, as a nonprofit legal aid organization and a legal support services support center in California, focuses on supporting those that are most lacking in resources and access in sports. Now, why does this matter? Why are benefits of sports so key? Well, we know from lots of research out there, and we're happy to send the studies if anyone needs access to the links, but we know that girls who play sports as they grow up excel in education. They actually have higher grades and higher standardized test scores than non-athlete peers, and they're graduating at higher rates than their non-athlete peers. And I like to, emphasize too on this point that folks might think sports is a distraction to girls or kids. It's an extra thing to do in your day, but we have found through our years of work and our own sports play and our own coaching that in fact, girls and kids stay in school because of sports. They can pull their GPA up higher and maintain academic levels of achievement so that they can stay on a team and play for that team. So it's often what keeps kids in school and keeps them very interested in their academics. Employment is another area where girls and women benefit when they played sports. So a neat study from an economist, Betsy Stevenson, showed that girls who played sports in high school go on to make, or are correlated to make, 7% higher annual wages as adults. I said it, that's 7%. It's really remarkable that girls who played high school sports have that 7% wage bump when they're adults in the workplace. We think, the correlation is based on all those great life skills you get from sports: teamwork, discipline, grit, resilience. And we also know from some really powerful studies that 90%, at least 90% of corporate suite women played sports growing up. So primary or secondary school sports are common amongst women who are in corporate executive roles. Finally, on health, we know that girls who play sports and young women are experiencing lower rates of breast cancer as they age as adults, and they're also experiencing lower rates of depression if they played sports. And we can imagine, physical wellness and exercise. This doesn't have to be Olympic or varsity or Division I athletics. This is girls and kids just running around, having a fun time, tend to have a lot of health dividends throughout their day-to-day lives. All right, so next, and Elizabeth, feel free to chime in. Of course, we love that slide on those details. Anything to add on benefits, Elizabeth?
No, I just want to acknowledge that this is something that we always bring to the conversation, because I think sometimes people lose sight of the educational benefits of sport, especially when there's this focus on the revenue aspects, the professional aspects. But this is really about education, and Title IX at its core is an education law.
Yes, thank you, Elizabeth. Yeah, we often talk with our training audiences about the co-curricular aspect of sports, as Elizabeth mentions, that people forget that, sports after school, following a school day, are supposed to complement the academics, not necessarily be apart from it. And yes, college sports have gotten really big, so sometimes people forget that co-curricular aspect. So thank you. All right, so we're going to dive into Title IX. What is it? And many folks, in our Zoom room today and watching the recording, again, might have a kind of vague sense. Oh yeah, I've heard of Title IX. I know it opened doors for, say, girls and women in sports or in school, but they don't know much more. So this is exciting to equip the legal aid orgs on the call and other stakeholders with this information. So it's a federal law that prohibits sex discrimination in any school or college receiving federal funds. Even just $1 of federal funding for a school or college or university, even a preschool receiving federal funds, would be subject to Title IX. And it means that by taking those monies, you're agreeing not to discriminate based on sex. This law was enacted in June of 1972, 54 years ago as of today. It had a lot of bipartisan support, and there you see Patsy Mink, the congressperson who helped pass the law, with Edith Green and Birch Bayh. One fun fact about Patsy Mink, of many, she's wonderful to study if you have time to learn more about her, is that she was denied admission to medical schools and pursued law because medical schools would not take her because of her gender as a woman. And then actually went into Congress because after graduating from law school, she was denied opportunity to work in many law firms. And, her being a woman really was a barrier to her pursuing her dreams. And so she did pursue an amazing career as a congressperson and help pass Title IX based on some of that foundation and those experiences. So in terms of Title IX, it applies to any school receiving those federal funds as mentioned, and it's based in every state of the United States. So it's not different in California or New York. It's the same in Florida and Arkansas, Alabama, everywhere. Title IX applies to schools and colleges taking federal funds. Athletics programs are covered as educational program and activities under the law, but as mentioned, like medical school or law school or any kind of academic program would be subject to Title IX if that school received $1 of federal funds or more, but athletics is part of that. So that is the primer on Title IX in the big picture. So I'm going to pass it to Elizabeth to get into some of the more specific details.
Thanks, Kim. And I just want to again highlight Patsy Mink. I put a link in the chat to an article about our long-running case in Hawaii. It's called Tidal Waves, and it's really about how Patsy Mink's legacy was carried forward and what kind of history there was in Hawaii before Patsy Mink, and then carrying it forward to the present day with the young women in that case that we brought against Campbell High School, really achieving equity for girls and women in Hawaii as part of a class action case. So I'm always happy to start with Patsy Mink. The law has been renamed for Patsy Mink, and it's a really important moment to remember her and her legacy. The law sounds quite simple, and that's the 37 words of Title IX on the slide, that essentially no person shall on the basis of sex be excluded from, or denied benefits of education under activities that receive federal financial assistance. And so as a former Title VII litigator litigating under the laws that prohibit employment discrimination, I expected that this really robust civil rights statute would sort of have the same amount of cases, the same legacy. But what I found as I started litigating these athletics cases is that you could read all the Title IX athletics cases in one afternoon. Whereas if you tried to sit down and read all the employment discrimination cases for a statute that's been around almost as long, I think it would take you probably a whole year. So there is something fundamentally different about Title IX and about making sure that we have gender equity in athletics. We're really only covering that part of Title IX. It's certainly much broader. It covers things like employment in educational settings, and that issue is in front of the Supreme Court next term. It covers making sure that women are admitted to school. I know that when my mom went to law school, she was one of 10 women in her law school class, whereas when I went to law school, it was 50% women. It covers sexual harassment and assault. There's been a huge amount of changes in that area of law. It covers LGBT students, again, a dynamic and evolving area of law. Covers pregnant and parenting students. And so it's a really much broader area, and we're focused on athletics. So athletics laws are technically enforced in part by the U.S. Department of Education Office for Civil Rights. And so before last year, that was something that we would often recommend to people who would contact us if they didn't want to pursue a lawsuit, if they weren't able to resolve things informally with their school, we would recommend that they file with OCR. In the past year, OCR has closed many of its civil rights offices. It has consolidated all of its work into 2 different offices, lost 54% of its attorneys, and has really begun a narrow focus on pursuing cases on that are essentially trying to stop transgender athletes from being able to play sports. And so there's been big changes. I don't recommend people go to the Department of Education to enforce their Title IX rights, but we do have a lot of self-help materials for people about what is the law. And there's a lot of educational institutions that want to work cooperatively and resolve these issues. And so we've had some great success with those pre-litigation resolutions. And we also have had success in litigating when we have to. Next slide, please. So in addition to the law, there are some really important Title IX regulations and guidances that have been issued by the Department of Education over time. And so what I would say about these is that these are also currently under attack. There has been a pretty concerted effort from certain segments of the right wing to say that essentially all of these Title IX laws and regulations should be thrown out because of changes at the Supreme Court. So far, those have been unsuccessful challenges. And so these Title IX regulations and guidances still provide really important background and guidance for people bringing cases under Title IX. So there's a 1979 policy interpretation, which provides essentially the framework that explains the different kinds of Title IX athletics challenges that can be brought. We'll go over them again, but it's going to be about equal participation opportunities, meaning girls and women have a chance to play. And then treatment and benefits, which is once you're playing, are you getting a fair share? Are you getting locker rooms, coaching? And then the anti-retaliation provision, which is really important as well. And at the high school level, we don't talk a lot about scholarships and financial aid, but that's important at the college level for sure. There's a number of guidance letters that are still really critical. The 1996 three-part test letter is something that we use all the time. We'll talk more about the three-part test. There's a letter around what qualifies as a sport. This comes up a lot when people want to know about other activities at school that are very athletic. Do those count as a sport for Title IX purposes? And there's very specific guidance and tests around that. And then there's another clarification letter that's important in terms of how do you assess interest, which is part of the three-part test. And so next slide, please. Back to you, Kim.
Thank you, Elizabeth. Yes, thank you. Yes, indeed, there have been some changes, big changes at OCR, as Elizabeth mentioned, in the last year plus. And that being said, what's interesting too, to Elizabeth's point, is that some of the OCR guidance still stands and is still critical and still being heeded by, I think, a number of schools and districts, regardless of administration changes. So, and I do know that certainly the OCR staff has, been diminished, literally excused from their positions. So the capacity at OCR is less. I do know there are some career staff members there that are very much trying to continue to enforce those key principles, and we hope that that will continue. But to Elizabeth's point, and some materials we can talk about later, there are other ways to enforce Title IX. So if there's not a feeling for good reason that an OCR office would pursue a complaint on your behalf or your client's behalf or in your community, there are thankfully a lot of ways to enforce this law beyond OCR. So essentially, and anything we mentioned that is kind of a little more weedy or a little more dense and textured, please do reach out, because we really enjoy, to Elizabeth's point, unpacking some of the law. Like she said, you can read a lot of these cases in an afternoon. You can learn very quickly a lot about the law, but we are also very interested in handing these keys to others, because we do need more lawyers and legal aid lawyers, especially in low-income areas, helping students with access to Title IX rights. And explaining to institutions how to avoid problems so as to avoid, say, a lawsuit. So there are three areas. Elizabeth previewed them for us. Thank you. Equal participation opportunities, equal treatment and benefits, and anti-retaliation. And so in any training we do, we try to explain to the stakeholders, these are the three buckets that anyone should know about. And they're pretty intuitive, which is nice in terms of how many teams and roster slots are offered across the athletic program. We do focus a lot in this training and in general on high school. There's only a handful of attorneys in the entire country that do high school Title IX cases. You would think it would be more, but it's not a whole lot. So we do like to share the keys to high school cases in particular, since there's not a lot of training on it. And then treatment and benefits, we'll get into those details on what are the program components. We call it the laundry list. And Elizabeth will touch more on anti-retaliation protections afforded by Title IX. Because it's hard to raise your hand and speak up against a school or institution, and especially a smaller community. Everyone knows each other. We all hopefully want the same things, and access and equity and positive sports for kids. But this can be difficult issues, and it's important to protect any complainant from backlash. All right, so Elizabeth will now get into the participation opportunities analysis, and then I'll do some treatment and benefits discussion.
Did you say weedy, Kim? This is where we start going into the weeds. And Kim lets me talk about this because it's my favorite part of Title IX. I think the three-part test is a really interesting test to apply, in part because I was an employment discrimination lawyer for such a long time, where proving intent was so complicated and really turned so much on who said what and when and how and what were they thinking and what did they mean. Title IX starts with the premise that you're allowed to have sex segregated teams. And Kim and I can talk a little bit later about how things are changing over time now that our society is evolving to not see sex and gender as a binary. But Title IX really looks at sex and gender as a binary. There are women's teams and there are men's teams. And because of that, if women as a whole are treated worse than men as a whole, it's considered to be a Title IX violation. And you can have an independent Title IX violation on the three-part test, which is Kim's previous slide, the second part, which is treatment and benefits, which we'll go over in a little bit, and retaliation. And so you really can have independent violations of Title IX. So the three-part test sounds complicated, but it's actually pretty simple because most of the activity really is in the first part. So the first part of the test says that a school can be in compliance with Title IX if the percentage of female students essentially matches the percentage of female students who have a share of the athletics program. And we'll go into an example of that on the next slide. When that's not the case, you then have to look at how many slots would we have to add? It's worded as the underrepresented gender, but that's almost always going to be girls and women. So it's how many slots do we have to add so that girls and women could have equity, essentially proportionally represented to their numbers in the student body. And if that number is enough to create a viable team, then the school is not in compliance with Part 1. Now, that doesn't mean that they're not in compliance with Title IX. You do have to look at Parts 2 and Parts 3 of the test. But what I have found in litigating cases against high schools is that most institutions will not meet prong 2 or prong 3. And so if you show a violation in prong 1, you essentially can win your case. And in our Ollier versus Sweetwater case, we did win this claim on summary judgment because we were able to show that there was essentially enough facts so that we should win without having to have a trial. So moving on to Part 2, the institution can still be in compliance with Title IX if they show that they have a history and continuing practice of program expansion. What this means is that they have to have expanded program offerings for women and girls over time. It can't be add a team, take away a team, add another team, take away 2 teams. It really has to be a steady march forward. This made a lot of sense when Title IX was adopted in the 1970s because you would think, yeah, sure, schools need time to add teams and programs and reasonable opportunities for girls and women. But we find pretty much today that after 54 years, it's very difficult for a school to show that they consistently added teams and levels for girls and women, and yet they're still not in compliance with substantial proportionality. And as Kim will talk about later, we have a state law, the Fair Play for Girls in Sports and Community Recreation, that has actually sunsetted this Part 2 so that communities can't use this anymore. The final part of the test is full and effective accommodation. And this is essentially saying, okay, girls are not getting their fair share of sports opportunities. The school hasn't added enough sports for girls and women over time, but they're actually fully and effectively accommodating all the interest among girls. Again, this made sense at a time when people thought that girls and women maybe didn't want to play sports. Maybe they wanted to do something else. But now, whenever we see a prong 3 argument where we're talking about full and effective accommodation, we always have more interest from girls and women in wanting to play sports. And so there's different ways to show full and effective accommodation. For a while, schools were trying to say that surveys alone would be enough. Surveys are one tool. Again, most high schools have not conducted surveys. Colleges are more likely to have done so, but surveys alone are not enough. So you have to do surveys. You have to be looking at what club sports might exist in your institution, and you have to look at your surrounding community and what sports are being played there as well. So that's the quick overview of the 3 parts. And now we'll go into an example of substantial proportionality. And Kim has made it easy for us because the math is easy here. So in this example, there's 1,000 students enrolled in this school, and it's 50-50 women and men. 50% of the student body is female, 50% is male. There's 200 students playing sports, and you're looking at 70 girls playing sports and 130 boys playing sports. So you look at the percentage, only 35% of the athletic programs is going to girls. And so you look at this next side of the slide, the calculation, girls' share of students is 50%. Their share of athletics is only 35%. There's a 15% gap. Now, that gap, the percentage number does not end the inquiry. You have to then look and see, well, how many spots would you need to add? And this makes sense because you could look at schools of different sizes. If you're at a really small school with 100 students, a 15% gap might not be enough students to add another team. But at this school where there's 1,000 students, there's 60 additional spots that could be added to create parity. And so this is an example of how the school would not be in compliance with prong 1. Then they would have to show compliance with prong 2 or 3. And if you're sitting there wondering, like, where am I going to get these numbers? How will I find out? There is a federal database that does show some access to numbers. I find it to be quite out of date. We're lucky here in California, we have some amazing laws. And one of the laws says that high schools have to give the California Interscholastic Federation data about how many kids are playing sports, broken down by gender, broken down by sport, and they have to post it on their own websites. And so I will post a link in the chat to the CIF data. And if you're interested in looking at a local school in your community, you can look at the data. Kim and I can always help you with the calculation because we shortcut that part. It's actually, slightly more complicated than just magic. It says 60 on the slide, but we will be happy to talk to you about that. And the data is now available. And so you can look at your local schools. Over to you, Kim.
Thanks, Elizabeth. Great. So the group is already becoming an expert. You've come so far in this first half hour. I do, in a moment, want to make sure that we check on questions. As we mentioned, we were going to get a little more into the details and texture of this. So if folks need clarification on anything, we'd like to help with that. And I do want to add to Elizabeth's points on some real world examples that I hope will further illustrate what we're talking about. So many years ago, when we were both at a qualified legal services project, one of the organizations in California in the Bay Area, we helped in a high school where these numbers were effectively what we were seeing. And girls volleyball was a very popular school sport. So maybe 100 girls were trying out each fall season. And I played volleyball growing up. Every fall, 100 girls were trying out for, the one team that the school was offering for girls. And then they were turning away 75 girls from they wouldn't have a JV or a JV2, but they would have 3 or 4 levels of football. And sometimes they would be adding new levels of football for boys every time new boys expressed interest. So what we often see is that lack of prong 1 compliance, and then maybe that fits and starts adding of teams for girls over the decade since 1972. And then very clear evidence under that prong 3 assessment that girls do want to play sports in higher numbers and would very much like more teams, but the school is not setting the table so that girls can pull up a chair in the ways that they're interested in. The good news is there's a lot of low-hanging fruit where athletic directors and school principals, community members, and local advocacy organizations can easily show, hey, we have, again, 50 girls showing up for JV soccer. Let's add another JV team for girls soccer and not turn these kids away. And we know too, as we talked about earlier, like the high rates of depression and the high rates of unhealthfulness that especially tweens and teens these days are experiencing, having a constructive opportunity to play that school sport, even if it's not super high level, they're not champions, but they're making friends, they're learning new skills, they're physically active, they're getting supervision from the school. For working parents, a lot of the clients we've worked with through the years are very busy, and having an after school activity for your child is extremely helpful for communities. So those are just some examples of what we've seen. And we think that there is tons of opportunity to address those gaps. All right, so I will now turn to equal treatment and benefits, the laundry list. That's the second part of those 3 pools of Title IX. This is a fun one, again, because I think it is very intuitive and people can picture what we're talking about. And these are all the issues that Office for Civil Rights or a judge, say a federal court judge, or various bodies would look at if they were assessing a complaint around gender inequity in school sports. So I'm just going to run through the items, and then I'm sure you all can imagine from your own sport playing days, or if you didn't get a chance to play, maybe you had a sibling that played, or at your school, you can recall these issues. So equipment and supplies, making sure the girls have the uniforms and gear that the boys teams have. And I'll actually unpack some things that people find sometimes confusing, or that the myths that we can bust. So the equipment and supplies for boys and girls teams don't have to be precisely the same. So it's okay that a football uniform might cost more than a girl's track and field uniform, as long as they're equal in quality. So they'd be top quality, mid quality, even low quality. We know sometimes JV gets the hand-me-downs from varsity. That's okay, as long as that's true on the girls and the boys side. Facilities for practices and games, another critical laundry list part of the assessment. And this comes up all the time, where girls say softball will be off campus, far away from the high school, and boys baseball will be on campus at a prime facility that's right next to the locker rooms and the classrooms. So we've had experiences and seen a lot where girls will have to drive in their own cars or walk, or somehow arrange transportation to far away facilities. And then this also relates to scheduling below that, where we see not only quality being different for girls and boys teams, maybe again, like girls soccer is on, kind of a cow pasture with lots of divots and lots of holes in the field, and it's not tended, it's not mowed, but boys soccer might be on a turf field that is far better in quality and more year round too, can withstand rain. So not only facility quality, but then the scheduling of facilities and the scheduling of practices and games. So we often see girls basketball scheduled for sometimes literally 6 or 7 a.m. before school for practice. And then boys basketball might get that 3 to 5 p.m. prime time after school slot. And then same with game times, maybe game time for boys basketball that's prime time, 5 to 7 p.m. on Friday. The whole school can come, the principal, superintendent come, parents and guardians. But then girls basketball is 2:30 on a Thursday, when parents and guardians can't get off work to come watch the girls play. And also more opportunities to practice and to play in games. Skipping back up to locker rooms and team rooms, there is a lot of inequity out there. And these are not made up things. This is literally years of looking at schools across the country, in California and beyond, in all sorts of areas demographically diverse. We see girls' locker rooms that are not outfitted, as well as boys' locker rooms, and same with team rooms. Things like having tiny lockers for girls in the locker room, and then having much larger lockers in the boys' locker or team room, so that they can put their gear safely stored away. Whereas girls might even have to carry their gear around the school all day long between classes because their locker does not fit their gear. Coaching quality and availability is another issue in the laundry list. Medical and athletic training facilities. So that's things like access to getting your ankles taped if you have a sprained ankle. We had one matter where football had their ankles taped for games, and all other athletes, boys and girls, actually didn't get access to the trainer, which was causing injury issues and particularly disproportionate effect on girls' teams and athletes. Publicity and promotion, so that's things like PA announcements, school banners, yearbook programs, all the things that go into making sure about when the games are happening, when a team is holding its tryouts. Maybe, for example, we had girls wrestlers that were in a championship and nobody knew, they were doing great, but no one knew. And yet boys baseball's schedule was everywhere, plastered across the school. Now we want the boys teams to be promoted, but we want the girls teams equally promoted as well. And it really doesn't take much to do that adjustment. Travel and per diem. Some of this is about college, like a per diem might be more of a college team issue, but even some schools will give like a dining allowance to a team after they come back from a game. And travel comes up all the time with buses, like a van for girls, teams to take, to go on the road to a game, whereas boys might have a fancy charter bus with bathrooms and TVs. And sometimes this is even low and mid-income schools that are providing those very nice opportunities, but really we see it across the board in schools all over the state and all over the country, regardless of the demographics of the school. We're seeing girls teams treated as a second class, and that can have a really corrosive effect on the girls, of course. And then collegiate sports, financial aid, housing, and academic tutoring, more an issue at the college level. And I just also like to remind folks before I pass it back to Elizabeth, that basically one of the biggest issues here is that, and the reason we really love this work is that school is a microcosm of the world. So if girls are treated as a second class and getting worse uniforms and worse lockers and the worst schedule, and then we say to girls as they become women, in a workplace, you should negotiate for an equal salary, or you should go for that promotion. but they're used to being treated as a second class and sort of put in this corner where you're by the school told that you're less than. That has a terrible effect on girls and frankly boys too, and kids of the school who see that inequity in that two-class or multi-class system. So this is a really good opportunity for schools and the decision makers in schools and school districts to make a difference for kids, to make sure they're treated equally from the start, because kids take those lessons into their later workplaces, their relationships, in their communities. All right, so we are going to give one quick example. Photographically here, you can see on the left side the girls' softball field. This is a real photo from a real case where a girls' softball field was down and out, dead grass, no landscaping, always in a terrible condition. And then on the right side, the baseball field, which is literally feet away from the softball field, was plentifully watered, had landscaping, had working fences, tons of care and good treatment. And this is again is a lower income community, but girls in this school across the board were treated unequally, and boys were often kind of treated like kings at the school. And yet, with the right intervention and legal help, the girls were able to assert that they, under Title IX, deserve better and now have that. And we're happy to say that this girls' softball field today looks much, much better. And there's a lot of equality at the school and at the district, which really started to embrace Title IX after a lawsuit was filed and won by the girls, the parents, guardians, and community members that brought the case with California Women's Law Center and another organization, Legal Aid at Work. All right, so I know we're covering a lot. I'm going to pass it to Elizabeth for anti-retaliation.
Yeah, and Kim, if you could just go back for a second to that slide. I mean, one thing that's so striking to me is that this girls' softball field slide, that's not the softball team that's on that field right now. That was a PE class, and the girls' softball field was used for PE classes 5 or 6 periods a day. And then their field was like the exit path for all the students leaving the school to get to the exit of campus. And when we brought this issue to the school's attention, they first said, well, there's a football team, so we're never going to be in compliance with Title IX, which of course is not true. There's no football exception to Title IX. It has to be equal across the board. And then when they made some improvements to this field, they did put some roofs on these dugouts eventually. But on the girls' side, they had stencils that said home and visitor that were like little white paint stencils, whereas the boys had like huge cinder block dugouts with, paintings of the school mascot. And so all of this stuff really does send a corrosive message to girls that they're not equal, that they're not worthy. And that's part of why we think the high school intervention and younger ages is also so critical, because if you don't intervene at these younger ages, girls don't develop the skills and confidence and abilities to play later on in college. And just the scale and number of girls playing in high school is, more than 3 million, whereas it's about 300,000 at the college level. Next slide, please. Thank you, Kim.
Elizabeth. Yeah.
Thank you for indulging me talking about my favorite case. So my other favorite part of Title IX is the anti-retaliation protections. And these are just absolutely critical. They do mirror the Title VII protections. And so essentially there's this idea that if you're going to speak up and complain about what you in good faith believe to be a violation of your civil rights, that nothing bad should happen to you. And if it does happen to you, you can bring a claim that says that this institution retaliated against you. And in the employment context, we often saw this as a direct form of retaliation. Someone speaks up and complains about sexual harassment, then they're demoted or then they're fired. In the Title IX context, what we'll sometimes see is group-wide retaliation. So a parent, in this previous case, a parent spoke up about inequalities on the softball field. And he was walking the field with the athletic director and the softball coach who'd been there for many years, very beloved and popular. And as soon as the parents started complaining about inequalities and brought up Title IX issues, the athletic director said, well, you know what, coach, you can get fired at any time for any reason. And then they did fire the softball coach. And what was interesting about this case is that we were able to prove not only the coach could have brought his own claim, he chose not to, but he would have been protected individually. What we proved in this case was that the whole group of girls at the school, their rights were violated as a group because of the chilling effect of that retaliation. And so Title IX has this kind of class-wide retaliation protection, which is a little bit unusual and different. And we had a similar claim in our Hawaii case where the water polo team was speaking up. And then the principal said something to the effect of, oh, well, should we just cancel, your whole team if you're going to be complaining about, not getting to swim in a pool. So that is the kind of anti-retaliation protection that's out there. It protects students and families, teachers and coaches. There's a Supreme Court case called Jackson versus Birmingham that's about a coach who spoke up on behalf of his girls' basketball team. He lost his job, and the Supreme Court found he was protected under Title IX's anti-retaliation protections. And so this is a really critical and important part of the protections, because if you can't speak up and talk about the violations, it's hard enough to do this. I mean, imagine being a middle school or a high school girl, and you have to speak up to your school, probably like one of the most important institutions in your life, about something that you think is going wrong. And so the fact that we have these anti-retaliation provisions is so important and needs to be really robustly protected. Back to you, Kim.
Thanks, Elizabeth. Absolutely. In that Birmingham case, the coach recognized that he wasn't getting access to the gym at the same level as the boys basketball team, for example. So back to those laundry list factors. And, also kids have a very acute sense of fairness. I joke a little bit that I have young kids myself, and they know if there's 4 chocolate chips in one cookie and 2 chocolate chips in another cookie. So it is really unsettling when kids are experiencing a very blatant, very obvious inequity. And yet there's so many ways to fix it and to work on it. And yes, to Elizabeth's point, it's critical to remind everyone involved that retaliation protections are afforded under Title IX. So any complaint should be treated very delicately and supportively. But it's not easy for these families, parents, guardians, coaches, and girls, and people. We've had actually, male students at high schools that stood up for their girl counterparts. There's a lot of allyship involved, or as Elizabeth mentioned in the Birmingham case, a male coach who spoke on behalf of his team, his girls' team. So anyone can be an ally. All right, so we are going to go through the next few slides a little faster, knowing that time is running quickly and we are having so much fun here talking about Title IX. We went over those 3 main pools of Title IX of what are those key elements: participation opportunities, treatment and benefits, known as the laundry list, and then anti-retaliation protections. And Elizabeth touched a little bit on the numbers. We're going to celebrate for a moment on the positive impacts of Title IX. So with all those protections and some of those cases mentioned, precedents set, and advocacy, we have come so far. From before Title IX was passed, we had less than 300,000 girls playing high school sports in the country. And today we have well over 3 million girls playing high school sports. And I think one really important part of this is that it's not that girls didn't want to play before, or that Title IX, forced them to play or created quotas, which it does not. It just said, if you want to play, if you're raising your hand, we will create space for you because you deserve that. These are public dollars. This is federal funding that should be afforded to all kids wanting to be active and be part of the school environment in a robust way. So really great news. And then the other myth that we hear a lot is that somehow Title IX is taken away from boys or men's teams. And in fact, it hasn't. So there were well over 3 million boys playing high school sports in 1972. And today there's well over 4 million boys playing high school sports. In the college level, it's the same, where men's opportunities in college have not diminished, they've grown, and still women are not at the same level as men in college sport opportunities in terms of numbers, and same with the high school level. So anyone who says, oh, Title IX canceled my team or anything like that, it's just not true. And I would say it's important to look at the growth, which is a valid sport, of something like football. What we often see is a school, even a high school, with not enough opportunities for girls or boys, in a sense, that then grows their football team by 3 times the size. So that football squad is really eating up a ton of resources that affects the entire athletic program, boys and girls teams. And so it's important to think about the pie in terms of all the pieces. But yes, overall, really good news, more girls playing, and even more girls that want to play and need equity, not only the opportunity to play, but a level playing field when they do. So when they take that slot, they should have the uniform, they should have the practice and game schedule they deserve, the coaching quality, et cetera. All right, so last item on Title IX, and then we're going to switch over to the Fair Play Act, the Park and Rec law. Thanks, Elizabeth.
Yeah, and this could be its own entire presentation. It's a little difficult to present on the current state of the law around transgender athletes because it has been really constantly evolving over the past few years. There has been some great developments. Bostock versus Clayton County is an amazing Supreme Court case that found that sex discrimination under Title VII includes sexual orientation and gender identity. It is under Title VII, but it's instructive for Title IX. Our California Education Code is very clear that trans athletes should get to participate in the sport or team that aligns with their gender. And California Interscholastic Federation has been defending this. The United States Department of Justice has been suing the California Interscholastic Federation over this very rule, saying that it violates the federal constitution. And there are 2 cases right now pending with the Supreme Court. We thought they might even come out today. So far, we're still waiting on the rights of transgender athletes, both at the college level, a case called Hecox, and at the high school level, a case called BPJ. And the California Women's Law Center submitted an amicus brief in the BPJ case, essentially trying to frame this issue to say, there should be inclusion, but also this issue is really being used as a wedge issue, and transgender kids who play sports should get all the benefits of Title IX that we're talking about. And so it has been a really complicated, difficult issue right now, especially with all the changes. But we did want to flag that this is out there. And so people can be looking for what is the Supreme Court going to do on this issue. And we're a little bit fearful it's not going to be good news. California law may or may not hold up depending on how the Supreme Court case comes down. So that's something to keep an eye on for you Title IX watchers. Obviously, a really important part of our civil rights issues that we wanted to raise today.
Thanks, Elizabeth. And rounding that out, we want to pay attention to Trevor Project, which has some fantastic resources on inclusion and equity. And we really want to make sure that any kid, any person that wants to be active and play sports gets that opportunity, regardless of gender, gender identity, sexual orientation, race, socioeconomics. All of those factors are so critical to get all kids and people in the game. Thanks, Elizabeth. All right, so in the time we have left, we're going to go pretty quickly through the Fair Play Act, which is AB 2404, the California law that requires gender equity in youth competitive sports programs. We also want to share some kind of culture-based tips that we think can help institutions, nonprofits, advocates get more kids and girls in the game. We're going to go pretty quickly through these items, and I just want to preview for you that we do have a couple words on California Women's Law Center, the amazing legal aid organization supporting this work and this training today, from 1 to 1:15. So I will tick through these pretty quickly, and feel free to drop questions in the chat. I know Elizabeth is monitoring. If you have a burning question, you want to make sure to get in before 1 o'clock. If you have to hop, we want to make sure to get that question, and comments and celebrations for Title IX. So Title IX is the first portion. Now we're going to talk about this Fair Play Act, which is the Fair Play and Community Sports Act, California Government Code 53080, passed and signed into law is 2004-2005. In fact, it went into effect in 2005, modeled after Title IX, and it prohibits sex or gender discrimination in youth competitive athletic programs, applying to park and rec, youth sports that are run by the Park and Rec Department in California or run through third parties, which a lot of people don't realize that these are public lands. So the court, the basketball court near your home in California, the field, gym, etc., that is a Park and Rec facility is public. It's effectively the people's gym, the people's court, and we want to make sure everyone gets a chance to use these areas in a positive and equitable way. It's a law that covers participation and treatment and benefits. Just like Title IX, it's very similar. And it's also a model for the country. So California is so often pioneering, and Washington State actually copied the law in 2009 and added adult sports to their law, which would be great for us to add at some point. But we focus on youth, gender equity in our law, and there are other states that are developing their own approaches as well. Okay, so Elizabeth, over to you for the details.
Yes, this is a really progressive and interesting law. And as little known as Title IX is, Fair Play Act is very unknown among our community park and recreation programs in the state. In fact, Kim did some research back in the day to really look at who was even tracking gender data. And almost none of the park and rec programs were tracking the data. So essentially what the Fair Play Act does, it takes Title IX concepts and says that park and rec programs run by these public entities, cities, counties, various different kinds of park and rec programs that are publicly funded are not supposed to discriminate. And this law came about because there was a lawsuit against the city of Los Angeles where there were not enough opportunities for girls to play. This case was brought under constitutional law, but it really highlighted and focused on the fact that this was a problem throughout the state. Park and recreation opportunities are sometimes the earliest chance that kids have to play sports, to develop their skills, to become those amazing athletes later in life. And so it's a really important law that's not very well known. Next slide, please. And so the law essentially focuses on the same kinds of things we've been talking about under Title IX. They have a participation opportunity component with a two-part test, because as I mentioned earlier, that second part about history and continuing practice has been sunsetted. And so you can show as a city that you're complying with the law by saying that you're offering a proportional number of opportunities to girls in your community. And Kim and I have been looking at this as census data. Most communities are going to be about 50-50 as between boys and girls. And then the reality is that this law has been on the books for a long time, but most cities don't know about it. They're not in compliance with it. They're not tracking the data. They don't have procedures to do it. And when we get in touch with communities, some of them are very cooperative and want to make change. And we've had some great experiences with that. But some of them essentially say, well, we can't do that. Like, that's not something we can do. And so, we say, well, that's what the law requires. But I think a lot of park and recs almost see this as sort of an optional law. And so this is an area where there's been really under enforcement. And as far as we know, there's been not a single case litigated under the Fair Play Act, but it is something that we regularly work on as an organization and reach cooperative resolutions.
Yeah, thank you, Elizabeth. And, adding on to that, it's so critical Park and Rec offer equitable opportunities to youth because it's the lowest cost opportunity for so many families that are lower income. And unfortunately, for any of you that have kids in club sports or, are active in the youth sports community, it can be thousands of dollars, even upwards to $5,000 to $10,000 for a child to play in a season of club sports these days. And that's a whole nother dilemma that's needing to be tackled about the very high cost of youth sports participation. But in contrast, the Park and Rec might offer a soccer program, volleyball, basketball, baseball, softball for $100, $200, maybe a scholarship or financial aid. So making sure a girl that wants to play baseball, that wants to play softball, that wants to be on that basketball team gets that chance is so important. And so that's why we're very passionate about this law, because it is a gateway to school sports and to lifelong recreation and activity. But too often girls are very few in number in those public spaces and public leagues. And yet we also know from our experience that there are departments who have taken wonderful steps ahead to acknowledge the law and to be more inclusive for girls who are too often on the sidelines. And it's not hard. For example, we had one Park and Rec offer a volleyball girls league because it was very popular in the community, but they only had other sports, no volleyball. And within 1 year, 500 girls signed up and they were loving it. They were robustly participating and it was a real win for everybody. So happy again for folks to reach out to us if they need more information on this law, but we're pleased with some grant support over the years, actually, to have done training for Parks and Rec and for community members and other stakeholders on the law. So there's a lot to learn and to do. All right, so we mentioned we're going to go pretty quickly into the next couple of slides. I'm just going to quickly flag for you some of the things we've touched upon already, but today is also a rallying cry with Title IX's anniversary. It's what are we celebrating, but what do we have left to do? So we mentioned that boys still have a lot more opportunities versus girls nationwide in the high school level for sports. That 1 million girl gap still persists. It's enormous. And yet we know there's lots of low-hanging fruit and key ways to get girls in the game while maintaining boys' opportunities. As Elizabeth mentioned, we've done some surveys and we'd love to do more to assess, especially with the Olympics coming to California very soon. And I know the World Cup, the Men's World Cup is very busy right now. A lot of eyeballs on TVs are watching sports these days. But we want to find out what is going on at Park and Rec and in schools. And there is some good data out there that shows they're not doing enough. They're not quite aware. And yet it doesn't take a lot to be more aware. We'll get to some tools that we're putting out actually that could help in a minute. And then we found that self-reported park and rec data showed that it was about 1/3 girls in community youth sports and 2/3 boys, despite girls raising their hands saying, yes, we want more teams, we want to be more involved, but we're not feeling welcome, or for some reason we can't play. And then one California department soberingly shared with us that they had just about 10% girls participating and 90% boys across their youth athletic programming that is effectively publicly enabled programming. So that was a big call to action to help that department make a change. All right, so the next slide, it's a little bit more about practical strategies. Not only does the law help, the Fair Play Act and Title IX, but there are some kind of day-to-day and culture change issues that any community member, any legal aid, nonprofit, or other stakeholder can take on to make a difference. Auditing programs. We've talked a little bit about just knowing who's playing, girls, boys, kids of any gender, who's out there. Finding those baselines is very important. Surveying girls and women about their interests and what barriers exist. We know, for example, women coaches make a huge difference for girls getting in the game. Usually there's less than 25% women coaches in any given school or park and rec athletics program. But we know that women coaches are huge role models for girls to play and stay in the game. So getting more women coaches is huge. Active targeted recruitment strategies, making sure you're saying to women coaches and girls in the community, hey, you can do it. I want to see you at practice on Monday. You did a great job at the clinic we had. Now let's join the league that we're offering starting next week. Networks and community partnerships. Elizabeth and I have been fortunate to work with a whole lot of great nonprofits throughout the state and beyond that work on these issues, but definitely keep those networks going. And then we talked about women coaches and role models, but just cannot stress enough how critical they are. And then all girls programming has been shown to be very powerful for girls to get in and stay in the game. Of course, co-ed and mixed programming can be successful, but we find oftentimes girls enjoy an all-girl team or all-girls leagues if possible. So that is a key. All right, Elizabeth, over to you on systems and culture, and then we're almost wrapped on this part of our program.
Yeah, so we really believe in an intersectional lens on all of our work. And so we want to make sure people consider language access, culturally informed outreach, engaging men and boys as equity champions and allies. I think we need to harness this girl dad movement, which I think has been really effective at bringing some of these gender equity issues to some other folks who need to get into the fight. We believe in being inclusive of all gender identities and expressions. And again, that's been an evolving area with respect to Title IX. We want to identify and systematically remove barriers to girls' participation, whether that is they have childcare responsibilities at home or, in their culture, boys are allowed to play, but girls are not. And so we want to be really mindful in thinking about that. Apportion local funding equitably, and this is critical. I'm working on a case in a large city that shall not be named, where they gave a huge grant to Little League Baseball to build a state-of-the-art facility. It is like a little mini Dodger Stadium, and girls softball was playing on dilapidated fields with holes in the roof of their dugouts. And then when the city decided to help the softball team and make some repairs to the dugouts, they created a situation where the dugouts now flood with water every single time it rains. And they basically told girls, get back in line. When we have money, we'll fix the flooding problem that we created. And so we really need to look at this. These are our public dollars. We, who are taxpayers in California, are paying for these programs. And we want to make sure that the funding is distributed in a gender equitable manner. And you have to be persistent. We've been working on these issues for a long time. 54th anniversary of Title IX is certainly not the 54th anniversary of the work for gender equity in this country. This is something that's been going on for a long time, and we need to essentially redouble our efforts and stay vigilant.
Thanks, Elizabeth. Great. And so that leads us to a very exciting announcement that we are debuting today. Brand new CWLC materials that Elizabeth, I think, put in the chat, but could reissue in the chat around Title IX athletics and the Fair Play Act, AB 2404, so that folks, no matter your hat, no matter where you live, no matter your title, you are surely invested in equity, and you can use these tools. There are 7 resources. They're fun, they're engaging, they're easy to read. Thank you to Goodwin Proctor for helping us develop these materials, and a whole team of people at CWLC and beyond. So those materials are available on our website and in the chat right now. And then also thank you to the pro bono attorneys, law firms, and qualified legal services projects, the QLSPs, legal aid organizations across the state whom we partner with. So if you want to get more involved, you've already worked with us. I know we have a lot of folks on this call who have worked with us before. So shout out to everyone that we recognize, and shout out to the new faces, because we need more allies and advocates in these fights. So please do contact us if you want to work on anything together. These refresh materials, as mentioned, are one way that we can continue partnering. Send them around. If folks need in-person trainings or online trainings, we can conduct those. And so just flagging all these ways we can partner. You see our web address at the bottom of the slide, as well as the email address. And I'm going to leave you on this section with some last tackling inequity steps. And this is a recording, so you can revisit any one of these slides, but just want to flag these things and stay on for a minute for questions before we head to our organizational primer on what is CWLC. But please, today, tomorrow, next week, next month, next year, you can identify the issues about inequity and gender with respect to sports. You can gather data, as we've mentioned, a few ways to gather data. You can conduct an assessment. You can start a dialogue or file a complaint with OCR or the federal courts, depending on the route you want to take. And we can help with those kinds of overviews. And then connect with CWLC. Tons of resources in the organization, tons of great, years of advocacy and support for these issues. So Elizabeth, do you want to add anything? And then we'll head to questions and our CWLC primer.
I just want to thank everybody for being here, for your attention to this issue that obviously we're very passionate about, and we're happy to see so many familiar faces, but also so many new advocates here. And we're happy to answer any questions. I've been keeping an eye on the chat, Kim. So far, there's been nothing that's come up that I haven't been able to answer in the chat. And so there's a number of links in the chat as well. So I think we're ready to move on unless there's any other questions. Don't be shy.
Yeah, thank you. You're welcome to use the chat. I think probably easiest versus coming off mute. And yeah, please don't be shy, and do contact us later if you have a question or something that occurs to you that, some of this seems intuitive and easy. Some of it is a little complicated. And so for the legal minds in the training too, it's a fun area of the law that a lot of folks don't know about. And it's such a critical set of civil rights protections that we can all wield in our communities and in our practice. All right, so I will next advance the slide to CWLC's overview. We're really pleased to use the next few minutes to give our audience, and through the recording, an overview of this wonderful nonprofit and all its great work, so that folks can find CWLC and get help and partner with us, and we can support the community at large. So over to Elizabeth.
Yeah, I'm very proud to be associated with this organization. It was founded in 1989 by three really visionary women who believed in this extremely broad mission that we need to create a more just and equitable society by breaking down barriers and advancing the potential of women and girls through litigation, policy advocacy, and education. And this organization has stayed really true to its mission over these many years. There's still a number of really critical areas where our work is needed. We're a small and mighty group. There's about 6 of us right now at the California Women's Law Center, but tackling a huge range of issues. We show some of them on the next slide. We're working in the area of economic security, areas like pay equity, housing stability. We've talked a lot about gender discrimination under Title IX. In athletics, but we also work on some of the other Title IX issues that I touched on. We work on women's health, especially reproductive rights and issues around crisis pregnancy centers and keeping them accountable in California, and violence against women, domestic violence, sexual assault, especially where it overlaps with housing. We provide legal education, like this kind of webinar and training, as well as our materials, technical assistance. And so especially if you work for a legal aid organization in California, please reach out to us with any questions that you have around gender, around any of our subject matter areas. We're happy to help or get you connected with the right people who can help. And we work on advocacy support. So we advocate for new laws in California and also to protect our really great existing laws that we have in California.
Thanks, Elizabeth. So a little bit more about CWLC in addition to that great foundation. So CWLC has long been designated as a nonprofit support center, providing legal support services to qualified legal support programs statewide, as well as related entities. We know that it's really a village that helps folks get the legal help they need. I know that LAAC did a great job as the training was beginning, highlighting how concerning the state of legal aid is and legal services in California, such that not enough people are getting legal help that they need, especially lower income people are not getting enough legal help. So we're very proud at CWLC to be ensuring that we're helping as much as we can in partnership with QLSPs, the legal aid organizations on the front lines. So we know that if folks can understand that they indeed have a civil legal services problem and they can find help for that, that is a win to make sure that our communities, especially those who are most vulnerable, can find help and stabilize themselves and or their families across a wide range of issues. And Elizabeth touched upon the issues that California Women's Law Center works on, and we are unique with our lens on girls and women in the state of California. We're a very large state, so we have a lot of ground to cover and a lot of folks to help, but we're very pleased to have that lens of fighting gender discrimination in all sorts of contexts. As noted on the prior slide and here, our bread and butter is legal training, legal technical assistance, and advocacy support, and which can include not only the bill drafting and the commentary on bills that Elizabeth touched upon, but also co-counseling where needed with qualified legal services programs and projects on the key issues because there is a lot of legal help needed. And we do, let me just say for the lawyers, many of them are lawyers in this Zoom room. It's impact litigation, or it can be direct services. And some of the cases that Elizabeth touched upon earlier are impact litigation to preserve standards that are critical to make sure these civil rights are continuing. We know right now a lot of standards and civil rights are being attacked and are being undermined. So I'm really proud that CWLC is at the forefront, along with a lot of our partners, to protect these core civil rights provisions. So we touched upon a couple of those issues. I won't go through them again, but you know the issues and you see now what CWLC works a great deal on. We do, again, work a lot with legal aid attorneys, pro bono counsel, and partner orgs across California, including those materials we mentioned that we're putting out as of today. That was a great example of the partnership that we have with so many different stakeholders. And we just hope that folks will reach out when and if they have questions, they need support, they need training, we're ready for it. And yeah, really wonderful to be together for Title IX's 54th. We do have a couple extra minutes. If folks do have questions, we would love to hear them. And it can be really anything, don't be afraid to ask. And often if you have the question, someone else does. So feel free to ask your questions or share your comments, or maybe you have a victory story to share that maybe on the Title IX front, something's going on in your community that we or others can learn from, because we also like to share best practices when we hear of a school or a park and rec or a community member or a legal aid nonprofit doing something that's really working. We should replicate that. And California has also been a leader for other states, which is really exciting. So any questions or comments in the chat? And Elizabeth, feel free to add if you like.
Yeah, while people are thinking if they have any questions, I'll just shout out a really positive story, which is the development of flag football for girls. This has been happening throughout the country, but I've been really pleased to see the development here in California and in Hawaii. And I will say that some flag football players from a local community high school contacted us last summer and said, our school won't add flag football. We want to play. They know there's interest. We have enough girls to form a team, but they want us to wait, and they want us to wait until next year. Well, of course, high school is a very short time horizon, and a number of these girls were seniors, and they were going to miss an opportunity to get to play flag football. And so in a very cooperative and positive resolution, we reached out to the school district, talked with their attorneys, had a few calls with them, and the school added flag football that very fall. And I went to a flag football game, and the girls were incredibly grateful to have gotten to play flag football their senior year of high school. So I think there's a lot of schools doing the right thing. There's a lot of wonderful advocates out there who are doing this work in their communities. And so wanted to leave things on a more happy, positive note. And there's a question about flag football in the chat, and it's a question about whether there's a scholarship opportunity in college. And this is a great question, because for a long time, the Title IX community was pretty divided about whether flag football was a really good opportunity for girls, or whether it was sort of a dead end because there wasn't going to be an opportunity to play in college. There's been a real growth in opportunities for girls to play in college, girls and women. And I will say that based on those numbers that we talked about earlier, with 3 million girls playing in high school and only 300,000 playing in college, I still think flag football is a good opportunity for girls. And I do hope that the college opportunities will continue to develop. But great question.
Yeah, thank you, Elizabeth. I love that on flag football. And, I think something we've also seen through the years is that we want to add opportunities for girls where they want to play those sports, but we want to make sure that the bells and whistles are there, no matter the girl, the woman in college or K-12 schools. So what we've seen sometimes is a sport added, which is wonderful, but then the girls may not get the training, like athletic trainers for safety, or the coaching stipends that they need for that team to succeed. They might get kind of like a half opportunity where they're given a team and a chance to play and practice, but then it's a volunteer parent coach instead of a stipended high school coach that the boys basketball or boys football team has. So I would entreat everyone who's thinking about new sports or something like the rise of flag football, or, field hockey, lacrosse, wrestling for girls has grown tremendously in California and the nation, and make sure that the schools and institutions that add those sports do it with all the bells and whistles that girls and young women deserve. Because otherwise you're kind of back to the beginning with not getting that full-fledged opportunity if they don't add everything they should. Hope that makes sense. Any other questions? That was a great one. I would just add too, for any folks out there who might be practicing Title IX law or interested in Title IX law, we have focused on the K-12 level, and we thus don't focus very much at all on financial aid or scholarships. And that is, we know that with NIL, name, image, and likeness, and the athlete collectives and some of the issues going on at the college level, it is extremely complicated and important what's going on at the college level. But our high school cases or middle school cases are relatively simple because you're not dealing with financial aid and scholarships and recruitment budgets and things like that. I'm a former college Division I athlete myself and know firsthand how complex college sports can be. But our cases are often, does the girl have an opportunity at her local high school? Does she have a bus to get to her games? Does her brother have a nicer locker room than she does? How can we fix that? There's something very not simplistic, but effectively like streamlined about these K-12 cases that make, I think, for lawyers that know complexity and probably practice in areas that are highly complex, this area of law is in some ways relatively simple. And I think it is very satisfying because when you get the result that the family and the organizations and the stakeholders want, it's fantastic. And it's very palpable. Like you can really see the difference in the community and the girls and the students, like almost overnight once they get the right resources and support.
And Kim, there's one more question in the chat about Title IX in college and the participation gap as between girls and men and women in college. I don't know if you have those numbers at your fingertips.
Yeah, I don't have them at my fingertips because of our youth focus. We can certainly provide those in the future, but we do know the gaps are similar. Colleges are different because they tend to have legal counsel. They still have a lot of inequity between the women and men's side, but the roster spots are monitored more closely, I would say, than they are in the K-12 level, because you have a lot more regulation, NCAA and others, because also a roster spot is tied often to a scholarship. There's a more kind of hawk-like watching of those roster spots. Now, that all being said, there's still a lot of inequity and there still needs to be more women's roster spots across the colleges of the country. But we believe, and I think this is fair to say, that the inequity between girls and boys roster spots in K-12 is way more pronounced. It's worse, which is why we really appreciate working in that youth space. But it is happening at all levels.
And I did find some data from the NCAA. It's a little out of date. It's from the 2021-2022 academic year, showing that male sports are 57%, and we can dig down into some more data on that. So I think there's still inequity, but Kim's right, it's not quite as extreme at the college level.
Right. And Accelerate Equity is a great website for those that want to look at a given institution, either that your kid is considering or your kid is at, your young person in your life, or you as a student are thinking about. What's really nice is like accountability comes through transparency. So one of the reasons we like to share these websites where you can examine your own school's data, college, K-12, et cetera, is that disinfecting sunlight casts some brightness on the issue. People don't always realize that their school is giving 60%, as Elizabeth said, almost 60% of the college roster slots to men versus 40-ish% to women until they get that big picture. So we're happy to help folks too if they're trying to look at a particular institution to dig down and find those numbers. I mean, the other thing is the power imbalance is a lot of parents, guardians, and students just don't have the big picture. They don't have the big spreadsheets that an athletic director or principal or superintendent would have. So we like to help people find the roots to that data, because you do need the big picture for these analyses to be conducted.
There's one final question, Kim, before we wrap up. And this is a question about assuming you can prove some inequity to the girls at the high school level. Is there a minimum amount of harm that you have to show to establish unlawful conduct? So what if in one area there's just like a small difference between girls and boys, but in some other area there's a big difference? How do you figure that out mathematically? It's such a great question. And this is very much where we use our expert witnesses. And so the methodology that we use is that we look at the number of male athletes as a whole, the number of female athletes as a whole. And then for every part of the laundry list, you look at different quality measures, and you look at whether there's a bigger percentage of male athletes who have access to, for example, superior locker rooms or superior uniform items. And then in the end, there can be some offsets, so if you're like, men are treated better in this area, but women are treated better in that area, sometimes they can balance each other out. But at the high school level, what we generally find is that because football and baseball are usually treated the absolute best, that those male athletes being treated better usually means that when you conduct the total program analysis, you find that there's essentially a violation of Title IX. And I'd be more than happy to send you some of the analysis that we've done, and also some of the way the courts have looked at this. Again, under litigated area, but there are some courts in our Sweetwater case, for example, where they looked at all the different components of the laundry list. So happy to share that. Feel free to email me.
Yeah, and thank you, Elizabeth. I think too, Elizabeth can recognize, we agree on this, is that sadly it's not very subtle usually. So what we notice in a lot of the high school and middle school matters that we've encountered is that it's so obvious that the boys teams, basketball, football, baseball, et cetera, are just treated so well. And the girls team are getting, kind of the crumbs of the school. So it's often not a close call. And like a young child could say, wow, I never want to play on this field, and I would definitely want to be on this field. They know the difference. Like you can just tell right away. So I mean, that's not a good thing, but it does make the analysis easier, and that almost anybody off the street without a Title IX expertise or even a law degree could know that this isn't equal and that we need to do something about it, which is why we're here and sharing those materials, and can't wait to help anyone with support they might need in the future. So thanks, everyone. I know we're at time, and I do want to pass it back to LAAC to wrap us up. Thanks, Elizabeth. Thanks, everyone.
Thank you, everybody. Have a good day.